Deputy. Oh, fuck, I'm late. No, that's all right. You're good. Thank you.
They don't care, huh?
Well, okay. Just anything you say can and will be used against you in my YouTube monetization.
Discord.
Hey, you can't let everyone know, all right? I'm
Good slap,
taking a federal exam right now.
Holy fuck. Okay, well, we're live. Hey, how's everyone doing? Oh, good lord. Okay. I definitely moved that guy's car into a red zone at the hospital, though.
Right.
Nope, tickets.
I'm gonna send that in RP chat. Hello, everybody. Welcome back to SLRP Court Night. I am here in a voice chat with a couple of folks. Kind of as usual, court is there's a lot of coordination that's got to go on here. So if you guys aren't familiar, I play as the district attorney for the county of Los Santos, joined here by my assistant district attorney. Fuck, I promise I know his name. Anyway. We're gonna get started with some court here shortly. We got a handful of cases to call, and we might see some traffic tickets. It's kind of the usual, so we'll see what craziness happens. Thanks y'all for being here. Should have just towed the car.
Oh, hi.
Lori's got her.
Me. There's someone yelling at the front door.
Okay, thank you. Michael, you gotta tell Lori to take her beanie off. Can't wear hats in a courtroom. And then when she when she fights
she just
you,
helped me out. She just helped me out by telling me there's someone at the front door, so.
That's all right. She'll be up.
I advised them all to turn their cell phones off.
Yes, I advised them
And
to
take
put them
their
on my
hats off.
All right, are we mostly ready then?
I gotta give Laurie shit here. Excuse me,
The
ma'am.
judge is just gonna go put his other
I'm gonna
robe
need
on.
you to
Be
sit
right back.
up and remove your hat, or else I'm gonna have to ask you to exit the courtroom for the time being.
Oh, my beanie.
Your toque? Yeah.
No, the fucking what the hell did you just no?
My hair's really nasty, and I kind of feel self-conscious.
If you don't feel comfortable taking it off, I'm gonna have to ask you to exit the courtroom, please.
Oh. Okay.
Hell, I'll violate her probation right now.
Thank you, ma'am.
Do I have bugs in my hair?
I'm not gonna get close enough to check. Please be seated.
All right, I'm ready from the judge's side here.
All
We
right.
only got 6 people in the courtroom, like civ-wise. We got all of the attorneys, but you know, If they're late, they're late.
All rise.
Should I just walk out, Mike?
Yeah, go first. Go first.
Oh yay, oh yay, oh yay. This honorable court, being the Superior Court of State of San Andreas in the city of Los Santos, is now open and sitting for dispatch of its business. God save the state and this honorable court. The Honorable Judge
I'll hold
Rhinequest
the door for you.
presiding. You may be seated.
You have to wait till he sits down, Sean.
Yeah.
And then tell him to sit down.
Actually, the judge
Oh.
should be telling them to sit down.
My bad. That is absolutely right. But yeah, I think the judge is
Seats.
supposed to say that.
Thank you.
Oh, I'm missing body armor because I dove out of my car during a test drive.
For anyone who it's their first time in court, please make sure you are shouting if you are addressing the court. Thank you. All right, the Superior Court of San Andreas, sitting in Los Santos, is now open for business. We'll start with the district attorney for the record.
I don't remember my bar number.
Just make one
69420.
I'm pulling it up right now. Thank you, Your Honor. I'm just getting my paperwork in order here. Thank you, Judge. On behalf of the state, Justin Pearson, my bar number is 239-087.
So noted. All right, Mr. Pearson, what do you got for me?
We have a handful of cases ready to go this afternoon, Your Honor. All of them, to my knowledge, criminal cases. Potentially one of the easiest to take first would be case 0130. This is going to be a plea by the defense and entry into the DUI diversion program.
All right. Diane Winslow, are you here?
Yes, sir.
You may step forward and be sworn. Bailiff, if you'll swear her in.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, ma'am, have a seat, and we'll have your defense attorney enter his appearance for the record.
Good evening, Your Honor. My name is Robert S. Zimmerman, bar number 241207.
Thank you, Mr. Zimmerman.
Michael, once we go on to the next one.
All
you
right,
can take
Miss
my
Winslow,
spot.
a couple things I want you to be aware of. You
Gotcha.
still have the right to remain silent. Anything you say here, there are several prosecutors, and they will use your statements against you. You have the right to speak with your attorney at any time if you're unsure before answering a question or if you'd like to confer with him privately. Do you understand all that?
Yes, sir.
All right. What I understand is happening here is you're going to enter a plea of guilty and enter our DUI diversion program, at which point the matter can be adjudicated separately. So there's some things I need to go over with you for that. But first, I want you to understand that if I accept your plea of guilty, you're giving up certain rights, like the right to appeal this decision to a higher court, the right to compel witnesses to attend court and use the power of the court to subpoena documents, evidence, or other information that may be relevant to your case. Are you aware of all of that? Your lawyers explained that to you?
Yes, sir.
Oh. And this is a first-time DUI, correct?
Yes, sir.
Yes, Your Honor, the state has verified that to be true.
Mike, I have Milo's messaging me saying he has a warrant, but how does he tell us? Like, he's in the courtroom right now and he has one of those warrants, probably failure to appear. Like, how does he bring that up? Or at what point?
All right. Without objection from the state, I'm going to approve this. So, Ms. Winslow, I need you to listen carefully. There's a bunch of things I need you to do.
Pretty sure
If you
there'll be a
don't do
time
them,
after
you're
all
going to
this
end up
where
back before me and you're going to
people
end
can
up
step
going to
forward
jail.
and
So, You are hereby entered into the DUI diversion program. This program will run for 45 days, and you must abide by the following conditions I am imposing. You are to pay a $500 diversion fee to the court clerk, and if necessary, pay court-appointed attorney fees. You are to participate in a drug and alcohol abuse evaluation program, follow through with any recommendations for drug and alcohol abuse treatment, and provide this court with a certificate of completion. You are to attend a Pedestrians Against Drunk Driving Victim Impact Panel, provide that certificate of completion as well. You are to install an ignition interlock device into any vehicle that you may operate if you are granted a restricted driving permit. You are to obey all laws, municipal, county, state, and federal. Do not commit new crimes, traffic infractions such as speeding or stop sign violation. If you are properly licensed, an ignition interlock will not count against you. Do not possess firearms, weapons, or dangerous animals. If you currently have any of these, you must surrender them to a friend, family member, or the sheriff's office before the close of business
What do we
tomorrow.
consider a dangerous animal?
Do not possess or consume any alcohol, narcotics,
Canadian
or
Goose.
prescription medication without a valid prescription from a licensed medical doctor. Do not enter any bars, liquor stores, taverns, or other location where the primary source of income is derived from the sale of alcohol or other intoxicants. You agree you will submit to random bodily substance testing, searches of your person and property if requested by law enforcement. You do not have to return to court to earn the dismissal. On the 45th day, the DA will review your case file for all the certificates and any further criminal history if applicable. If he finds you to be in compliance, he will certify that to me and I will dismiss the case. If the DA believes you are out of compliance, I will summon you back to court and you must appear. If you are found in violation, your diversion program will be revoked and you could be sentenced to up to 6 months in jail with a $1,000 fine and driver's license suspension or revocation or your your privilege to drive upon the roads of this state. If you have any other questions related to this program specifically, you can ask me now or direct them to your attorney.
I have none, sir.
Mr. Zimmerman, anything from you?
I have nothing, Your Honor.
All right. The defendant is to pay that $500 fee before she leaves the courthouse, be paid to the clerk of the court out there in the lobby, and make sure you get the rest of that stuff done. DUI, I'm not going to ask you why you did it, but it's not something that we take lightly. If you get caught driving a car without an ignition interlock and you don't go through the process to get a restricted driving permit, there's going to be some serious consequences. So what I'm going to do right now is ask you, do you need a restricted driving permit to get to work, to pick up kids from school, something like that?
Just to go to work, sir.
Where do you work at?
I work at Hookies as a waitress.
Okay, and that's a full-time job?
Yes, sir.
All right. The court will sua sponte issue a restricted driving permit for Ms. Winslow. There will be restricted to driving to and from work, as well as any doctor's appointments. And I'll permit you also to drive to pick up groceries. Other than that, you are not to drive without seeking further permission from this court. And if you're caught doing so, you will be arrested. You understand?
Yes, sir.
Your Honor, just
Alright.
a quick question on that. Is there a time limit of the restrictions that she has to be imposed upon? For example, is she not allowed to drive, let's say, between 10 p.m. and 6 a.m., or is it just those restrictions?
I was not leaning towards imposing a condition like that, since I know a restaurant like that may be open late into the night, and I don't want to stop her from getting to work if she's assigned a late night shift.
Okay. No, that's all I had. That's all I was just wondering, Your Honor. Thank you.
Absolutely. All right, Miss Winslow, please be good. Get this stuff done. Let's get this off your record and not have you back here again, okay?
Yes, sir.
And for the court, Your
All right.
Honor, the state would move to dismiss counts 2 and 3 pursuant to the plea offer extended previously.
I will accept your motion. I'll hold those charges in abeyance until the completion of the diversion program.
Thank you, Your Honor.
And that'll be all for this case. All right, what do we got next?
I believe the clerk of the court did send out a tentative docket, Your Honor. Might just be able to kind of run down the list. Except for I know that the first case is not ready to be called for another 30 to 45 minutes.
All right, since I already have you up here, Mr. Zimmerman, we'll go 0125.
Sure thing, Your Honor.
Believe this is an in custody defendant, correct?
Not 100% sure, Your Honor. I'm just looking through my notes now.
Your Honor, would you put the defendant's name on the record, please?
It's San Andreas versus Langley Fremont. Langley Fremont, I believe.
Yes, Your Honor. This is in regards to Mr. Fremont.
All right, Lieutenant, will you retrieve him from the custody suite?
Yes, Your Honor. Who am I getting? Who is this?
It's Reese for Langley Fremont.
There's two people in the cells, the Ramones, so just ask them which one's Langley Fremont, I guess.
Oh, there's two down there.
Also, he might have wanted the opportunity to speak with his attorney first as well, so maybe ask him if he wants that, and if he does, take his attorney down to him first so they can talk.
You can bring him up here and put him in the jury room behind us if they want to chat.
Yep, that'd work too. Oh, looks like I'm gonna have to go out and door watch for a bit because Mike D just joined. Maybe he's coming. I'll go out just to be sure. I'll go and stand out there for a bit.
You ought to feel included.
He said he's good. He doesn't need to talk to his attorney either.
What were you wanting to do with this case? As I recall, you guys are not taking the offer. Are you guys wanting to negotiate this case or just set it for trial?
Well, here's the thing. The form has put in as a Bartholomew A. Anderson, not a Mr. Langley Fremont.
Which one is that?
The 0125.
No, which document, though?
It is the criminal complaint signed by you.
I'm just gonna amend it right now. It's a Scrivener's error. It's not grounds for dismissal, so I'll work on filing an amended one.
I'll see what the judge says, but
I'm telling you, legally speaking, it's not grounds for a dismissal. But
And Lieutenant, you can remove his handcuffs.
Your Honor, something has come to my attention. There was a Scrivener's error in the criminal complaint filed in Mr. Fremont's case. There's just two locations.
I noticed.
Yeah, I'm gonna file an amended one right this moment, Your Honor. It is a Scrivener's error.
Mr.
Yep,
Fremont,
no worries.
Face me. Take a seat, sir.
And bailiff, you'll need to be sworn in if you want to get that taken care of.
We can take the plea deal once I confirm with my client.
It's absolutely up to you. I'm not playing hardball with
Sir,
you. I appreciate you
would you
letting me
please
know there was
rise?
that error. That's
Raise
my
your
fault,
right hand.
obviously. It's just it's a form template, and my legal assistant didn't correct it.
You
God
swallow.
forbid.
Do you swear to tell
Yeah.
the truth, the whole truth, and nothing but the
So-
truth?
Let me
So
I'll
help
talk to
you
my
God.
client first,
Yeah.
and then we'll see what we can
Thank
do.
you.
Yeah, I'll get the amended one filed.
Please
in a
make sure
second.
you're shouting, Mr. Fremont.
Of course, Your Honor.
All right, Mr. Fremont, while the DA fixes that printing error there, I want to remind you of a couple things. You still have the right to remain silent. Anything you say here will be used against you in this court of law and others. You can stop at any time to ask to speak with your attorney. If you want to consult privately with him, we have the facilities for that. We will accommodate it. You understand?
Yes, Your Honor.
All right. So as he's updating the complaint here, I'm going to go through what we need to go through based on what I understand to be a plea offer here.
Yeah, Your Honor. Can I just briefly talk to my client about this?
Sure.
I was under the impression that this would have been grounds for a potential dismissal. Unaware that it was a clerical error, and I think that my client would like to take the plea deal, but I just want to confer with him first.
Yep, absolutely. Bailiff or lieutenant, either of you, escort them to the jury room. Make sure they're whispering in there.
Alright, mister. Go ahead, we're gonna head over here to the jury.
My staff's told me, Your Honor, they've pushed through that amended complaint. Should be corrected now.
And Michael, we can switch if you want.
I was
There's
just out
nobody
watching.
at the door.
Yeah, but Mike D joined the server, and I was thinking he was gonna arrive down here, so I wanted to keep an eye out for him just in case. But no sign of him so far. Coming back in now.
Mr. Pearson, I think you need to find a new printing company. There's still an error on line 11.
Oh, you're kidding me.
But while you work on that, we'll begin here. So, once he gets back, we are looking at 2 counts. January 12th, 2025.
And then once he's back, Michael, and he's sitting in the chair, you'll just be chilling like that behind the prison.
Oh, you have to be behind where the chair is?
Yeah, when there's the guys up here, just in case he does
Okay.
anything funny.
Gotcha.
Okay. Yep. Should be in there now.
Oh, okay.
It's a new staff member we have.
All right, there it is.
I see you playing Snake.
Your Honor, do you want me to state my name and bar number for the record?
You're already on record for the previous appearance, so that's all right.
Okay. Your Honor, before we make the plea deal, before whether we decide to accept or deny the plea deal, my client had stated that he was arrested on the 24th of January. Case number is 52520. According to my client, he was in prison at that time in Bolingbrook waiting to be come into court. Can you clarify if that was the correct Mr. Langley Fremont? My client thinks that he may have been mischarged when he was in prison.
I will issue an order to the DA to confirm that, and we will hold that case off until we can clarify, because that definitely raises some eyebrows.
Yeah, and that as well, because I asked him, I said he said he wasn't released, and as far as I was concerned, I never got word that he was released from prison or made bail during that time frame. And he says he was in prison since the 12th of January, Your Honor, so...
Okay, we'll check the records to confirm that, and we'll figure out what's going on there.
Okay, and Your Honor, we will plead no contest. If the state will accept the plea deal, we will happily accept that as well.
Yep, the state has no objection to a no contest plea for the plea offer as previously extended.
Mr. Pearson, your plea offered acknowledging responsibility. Nolo contendere plea here would not match that. Are you willing to waive that?
In my plea offer, Your Honor, it is stated I'm willing to accept a guilty or no contest plea in the matter. Regardless, I do waive that. I'm willing to accept no contest.
Yeah, okay, because you have it as conditioned on stipulating to restitution and the acknowledgement of criminal responsibility for the purposes of restitution. So we'll assume that that's waived by the state.
The state will be requesting restitution.
Just the acknowledgement part we're waiving, right?
Correct, yes, sir.
Okay. All right, Mr. Fremont, there are 2 charges against you. One of which, Penal Code Section 25-400, carrying a concealed firearm, charged as a misdemeanor. So the potential punishment there is imprisonment in the county jail not to exceed 1 year, a fine not to exceed $1,000, or by both that imprisonment and fine.
Your Honor,
I'm aware that it's in the plea deal. I just have to read that to him so he's aware of the maximum potential consequences.
Okay.
And then the second count is malicious mischief over $400, charged as a felony in violation of Penal Code Section 594, subsection A, subsection 2. That offense as a felony, that offense would carry a jail term of not more than 1 year in this case, but a fine of up to $10,000, or if the amount of defacement, damage, or destruction, or the cost to replace the damaged items, if applicable, $10,000, or by a fine of not more than $50,000, or by both that fine and imprisonment. Plea offer I have before me, the state is willing. Concealed firearm. You will serve 7 months of bench probation with all standard terms of probation and special conditions for felony malicious mischief. To wit, you will pay $547.90 in restitution to the County of Los Santos, and you will complete 120 hours of community service with an approved provider within 6 months of this judgment date. The offer is void if you fail to appear when summoned, violate a release agreement, charged with a new crime, or if you have lied about your criminal history. You are stipulating by agreeing to this plea that you will make that restitution. And for the purposes of that restitution, we are considering, even though you're pleading no contest, that you're acknowledging the restitution. Further stipulate that you will appear at any restitution hearing should the state request one. And the standard terms and conditions of probation include not to consume alcoholic beverages, not to possess firearms, dangerous weapons, animals, anything like that. You're not to commit any new crimes. You're not to associate with known criminals, felons, gang members. You're not to do drugs other than by a licensed medical doctor. If you plead guilty or no contest here, as your defense attorney has indicated to me, then I will accept the terms proposed by the state. How do you plead, sir?
No contest, Your Honor.
I accept your plea of no contest. I warn you, you are giving up your constitutional right to take this matter further to appeal, to use the power of this court to compel witnesses, to compel the production of documents or evidence that may benefit your case. You still willing to plead no contest with that in mind?
Do I retain my rights to fight the other arrests that I was issued while I was
Yes,
at Bolingbroke?
this only applies to these two charges. And if you accept, count 1 would be dismissed and count 2 would be dismissed upon completion of the probation period and once restitution is made.
I do accept, Your Honor.
Very good. So the defendant is remanded to the custody of the probation department, have them do a PSI investigation, recommend any further conditions that may be necessary, and the defendant can be released at that point. I am going to add a requirement that you wear a GPS tether, so you'll need to wear that around. It'll be, I believe, attached at your ankle. You are responsible for keeping it charged. If it dies, they will alert me, and you'll be back here in handcuffs all over again. So don't tell me that it ran out of battery because you were late getting to your car or something. I don't want to hear it. Make sure that thing's on, and we know where you are all the time. Make sure your defense attorney can reach you if he needs to, because he's the one that's going to get the letter from me if I need you back here. All right?
Hey, Dalton, what's up, man?
Yes, Your Honor.
Very good. That case is adjourned. We will revisit in 7 months.
I put him back in cuffs, yeah.
Yeah. Oh, where is he going?
Oh. But did he not go back to the cells at all then?
Probation will reach out to you and
or let him out the
reach
back
out to
door
him
or
and
what?
You can take him down there and just like so he's changing back into his street clothes and stuff. There is indeed.
Chili Mike.
We can do that now, so I don't have to change characters more than once. Uh, 0126. Yeah, that is a pre-trial conference, so if you want me, since you're standing there, I don't mind flipping either.
Honor,
that was kind of funny, walking Reese out the back door, to which he immediately changed characters to a different guy in an orange jumpsuit and walked back in.
I understood. This court will be in recess.
Thank you, Ron.
Sean, all rise. Sean.
All rise.
The Honorable Court is now in recess. Perfect. Let's all go get some drinks. You may be seated.
Thanks for looking out on that one, Bossman.
Frick yeah.
I don't think they all know that they can go yet, Sean. They all are just standing there as if they're still waiting for you to say something else.
I advised them all that they're in recess. They can do what they want.
Get me some chips from the vending machine.
Is she talking to me?
How you doing, Miss Boyd? Oh, doing fine, doing fine.
Okay, thank you.
I'm gonna switch into my
Oh my
court
God.
clerk character and just be sitting by the desk. You know, immersion.
I know you don't have to say it.
Our kitten Rosalita.
You're welcome.
Rosalita clean.
It's what she lives for.
Is she on blast tonight, or she's just here working?
Just working, you know. She's taking the time during the recess to get a bit of cleaning done.
I gotcha.
How you doing, Bella? Is the judge in his office?
I believe so, yes.
Is she standing on his bench?
Oh.
Bold, bold woman.
Come on over here. Okay, I just want to make sure you're still not interested in the plea offer, right?
Correct.
These
Okay.
two in the pin suits.
Are you wanting to take this to trial, or are you wanting to try to negotiate a different deal?
We could try a different deal.
Okay, the question is, are you willing to admit guilt to this at all? So even if you enter a no contest plea, right? What you're saying by pleading no contest is, I'm not saying
What's
I
the
did it. I'm not
weight
saying
command
I
where
didn't
you
do it. But you're still going to be found guilty. It's going to go on your criminal history. You probably won't be able to work in this line of work ever again. So,
Just signs the checks.
you know, if you want to see if they have a different offer, because I agree the offer extended was ridiculous.
Yeah, wish
But
you'd bought better
if
coffee
you try a
for
different
the
offer,
office,
maybe
so-
probation or something. But like I said, you'll probably be out of this line of work permanently then.
I'm there till like
And I'm okay with
5
that.
a.m. normally, drinking
But if
on
it's anything
crappy
less
coffee.
than probation, then I say we take it to court. We take it to a jury trial.
Okay. Alrighty. So, they'll do the arraignment. This is where the judge is going to read the charges against you, tell you the
for yourself, I
maximum
get paid pretty
penalties.
well whenever
They're just the
I
maximum.
get those cases
Not
rolling in.
it's not going to be your sentence by any means. And then he'll ask us what we're going to do next. Tell him that we're looking for a pretrial conference. We're going to set that to the next Sunday court date, which is going to be March 9th. So on March 9th, we'll come back, and by then we will have had time to talk to the DA's office and either get a new offer, or we will we'll know where we're going next.
Okay, sounds good.
All right, perfect. You feel free to have a seat in one of these chairs here. There you are.
Right. And that makes makes our jobs easy, though. The DA likes to give in pretty fast. He has the whole motto of just let everybody go on a plea deal. Makes us look like we're actually doing something to get them off. You, if you're free. My retainer's 4,500 though. You think you can afford it?
Not on my salary.
I don't do pro bono work.
Or did I arrest him?
I hope
No,
he
you didn't.
fights one of my
Okay.
tickets.
What is
Yeah,
he next? Do I need to go down and get him?
No, not yet. He said he needs to step away for a minute, so we'll call somebody else.
It's not the other guy who's in the cells, no? Because there's another one down there.
I think we have
Ready,
Dallas
Mike?
and his case sitting there, Dennis. Yeah. Gotcha. Yeah, I just gotta let him know. He's already sitting there in the seats. William Stewart.
Stewart. Yeah, there you go.
William, what case are you here on today? Wasn't expecting to pay you to be here today.
I'm supposed to have two on the docket. Both are one's. Get my notes here.
Yeah, let me know what the case number
Well,
is.
one of the
Make sure
cases
we
he's
pay
here
you.
for is going to be mine, Dennis. It's going to be, he's like my attorney, but it's a quick one. I'm like just getting
One's
sentenced.
going to be criminal case 0113 for Boyd. It's a case that I received after the attorney had dropped to the law firm, and then second is going to be criminal case 014 or 114, which I was sought after, court appointed on that one. That's for a readout that's docketed for today as well.
Oh, gotcha. Okay, I had a different attorney on that case. I'll make sure I switch that. We'll get you paid. Thanks, William.
Excuse me, there's someone knocking on the door out front.
No, how about that? You must have heard me talking about crappy coffee he buys.
Excuse me, sir.
It's 113 as well. Yeah,
Didn't
I
we
said
already
plea
do
on that one.
Oh, that's the. Yeah, I got you.
Gotcha, but we're doing 126 right now. Perfect.
All right, Mike, if you give me the heads up, we'll get him up.
Go for it.
All rise. Court will now be back in session.
Make sure that in any event
The
you're
Honorable
speaking to the
Judge
judge, that
Rainquist.
you're standing up when you do that. I don't expect you to need to talk to the judge today, though.
Please take a seat, folks. All right, the next case I have before me is criminal case 0126, the state of San Andreas versus Stephanie Nichols.
Yes, you're.
All right, so we'll have the people make their appearance for the record and then the defense.
Your Honor, Frank Portola, bar number 249153 for the.
Thank you, Your Honor. Raylan Zane, 231065 from the law office of Raylan Zane.
Thank you, gentlemen. And bailiff, if you'll swear Miss Nichols in.
Miss Nichols, raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, Miss Nichols, you may be seated. What we're doing here is going to be a presentation of your indictment, probable cause conference, and then we will discuss the plea deal against you. So you have the right to remain silent. You do not have to say anything. Your lawyer can speak for you. Anything you do say may be used against you in this proceeding or others, and you have the right to request to confer with your attorney at any time. Do you understand?
Yes, sir.
You stand charged by the state with a violation of Section 368 of the Penal Code, crimes against elders, dependent adults, and persons with disabilities. It is a misdemeanor. It is alleged that on or about the 10th of January in Los Santos County, San Andreas, you did knowingly put at risk of harm or death an elderly male entrusted to your care. The relevant statute here states that any person who knows or reasonably should know that a person is an elder or dependent adult and who, under circumstances or conditions likely to produce great bodily harm or death, willingly causes or permits any elderly or dependent adult to suffer or inflicts thereon unjustifiable physical pain or mental suffering, or having the care and custody of any elder or dependent adult willfully causes or permits the person or health of the elder or dependent adult to be injured, or willfully causes or permits the dependent adult to be placed in a situation where their health or safety may be endangered. That's charged as a misdemeanor, and it's punishable by a fine not to exceed $2,000, 1 year in the county jail, or both that fine and imprisonment. Based on the criminal complaint before me, if the people would like to speak to probable cause.
Your Honor, one moment. We're just having a tablet issue.
It's the printing staff and now the IT staff. Jeez, they're a wrench.
Actually makes you take one out and fuck with it.
Black tablet too.
There you go.
Like spins it and shit.
Your Honor,
Can
sorry
Frank
for the
be
delay
home?
there. The state would like to recap that Miss Nichols has been charged specifically with crimes against elders, dependent adults, and persons with a disability. On the 10th of January in Los Santos County, she did knowingly put at risk of harm, injury, or death an elderly male in her care. The state has prepared discovery for the defense as well as a plea offer and is waiting to hear back at this time.
Okay, I find probable cause does exist to move forward. So, Ms. Nichols, what that means is your case now moves on to the stage where you will have to present a defense, and the state is going to have the burden of proving beyond a reasonable doubt that you're guilty of this offense. Now we'll discuss the plea offer that's put forth.
Your Honor,
Yeah, go ahead.
If I may, Your Honor, on behalf of the defendant, we have received the plea offer. We have reviewed it. At this time, we're entering a plea of not guilty to the charges. We acknowledge receipt of the charging instrument. I'd like to set this for a pretrial conference on March the, I believe, 6th. Give me 1 second to verify that date. Pardon me.
I believe it's March 9th.
Yes, Your Honor. It's going to be March the 9th. We would like to waive formal reading of the plea offer onto the record as we have reviewed it in detail.
Any objection from the people?
Your Honor, the state has no objection to setting this for a pre-trial conference, but we would like to ask the court if a protective order could be issued due to the delay here. Ms. Nichols should not be making contact with Mr. Grau, the individual she's accused of abusing.
You don't work for him anymore, right?
What are her bail conditions currently?
She has been released on her own recognizance.
Okay. I'm gonna, because I believe probable cause to exist here, I find you to be a threat to the safety of the community. I'm gonna revoke your previous bond and impose a $50,000 cash or surety bond that you must post before you're released. So bailiff, if you'll take her into custody.
Your Honor, on my client's behalf, I will post the bail today with the clerk of the court. In return, I'd ask that you do not take her into custody at this time, as I will assure you that... Actually, I'll write a check right now.
All right. So what I am gonna have to do before she can be released, though, because I did revoke the bond, is she is gonna have to be fingerprinted again. So
Absolutely,
I'm willing to let them do that now. Take her down there, get that done, and then you can post the bail with the clerk. I believe he's in the lobby there. I am not able to take the financial instruments. That's got to go to the clerk, but I am willing to take your word on that. I will also impose a GPS tether here, though.
Thank you, Your
Just
Honor.
given the crime alleged, I have very little sympathy for people who abuse the elderly. I'm not saying that she is guilty of that, but given the charges alleged here and the probable cause provided, I am going to insist that she wear a GPS tether while she's out on bail.
Your Honor, I would put to you that the allegation is not that she caused physical abuse to an individual. While as you know, I won't get into the facts of the case, but that she did not bring harm to the individual in the circumstances alleged.
So the people are asking for a protective order. Would the state like to clarify what protective order exactly is being sought?
Your Honor, without recapping details that were released at defense and discovery, Ms. Nichols did, through conduct of potential negligence, endanger Mr. Gao. I would prefer if there was no contact at this time.
We have no objection to a no contact order, Your Honor. My client's a very busy individual.
Is there any allegation that she has returned to the proximity of that individual in the time since she's been out on bail?
Not at this time, Your Honor.
And I can certify to the court she no longer works for the agency that provides care to the individual, and essentially the individual is a stranger to her, only known through...
All right. So I will accept... we will remove the GPS tether condition. We'll impose a protective order. You're to stay 500 yards away from that individual. And as an additional condition, you are not to work in any sort of a service capacity for elders, dependent adults, or persons with disabilities while this case is pending.
Thank you, Your Honor.
Additionally, the general terms of bail will apply once your lawyer posts this for you, ma'am. So you shall obey all laws, municipal, county, state, federal. You will not possess firearms, weapons, or dangerous animals. You will not leave this state without written permission from the court. You must update the court of any address change within 1 business day. You are to maintain gainful, full-time employment, schooling, or a combination of both if you are physically able. You consent to a search of your person, property, or residence without a warrant upon request from law enforcement. As I mentioned, you are not to return to the scene of the original incident or make yourself within 500 yards of the protected person, Mr. Gal. You are also not to possess or consume narcotics or prescription medication without a valid prescription from a licensed medical doctor. Do you understand all that, ma'am?
Yes, sir.
All right. Bailiff, go ahead and take her into custody for the fingerprinting, and then we'll get her back up here and release once Mr.
And that'll be all for my cases, Your Honor. With your permission, I'd like to be excused.
Absolutely.
Thank you, Your Honor. See you next month. Your Honor, I have some information pertaining to that previous case, 52520.
Yes.
So it looks like the defendant in that case is going to be an individual by the name of Bishop Ruiz, not Mr. Fremont. As it so happened, Bishop Ruiz provided false ID to a peace officer during his arrest, and that was found out during the booking process at Bolingbroke. So we have amended the arrest report and criminal complaint to reflect the Bishop Ruiz name and charge them additionally.
I expect you've added. Okay.
Yes,
very good.
absolutely, Your Honor. That was the second thing we did. So that
Don't
has
much
been
like
clarified.
people trying to BS me, so that I would expect you to add an additional charge there.
Absolutely, Your Honor. So that should be cleared up, and we'll get that cleared up with the jail as well to ensure
Mr.
that he's not
Zimmerman,
in
please
custody.
accept my apologies on behalf of the court to your client. If you could convey that to him the next time you get a chance to speak with him.
Yes, Your Honor. I'll make sure that he's very well aware that it was
Get out of your way. I think you got like 2 cases coming up.
Identity theft.
An identity theft, and therefore the person will be charged accordingly.
And you can let him know that I will be instructing the sheriff's office that they need to be confirming that sort of thing before they file it with me. So
Sounds good, Your Honor. Thank you.
absolutely.
Your Honor, I do want to bring up something, if this is okay, in regards to a civil case in regards to.
Is this a matter best
security.
handled in chambers?
It can be. It's just more so a guard card revocation where you had issued
yes, I'm
out a
familiar.
warrant.
Yeah, you can address that. Is your client here?
I'm not 100% sure if he's here, Your Honor. As I told him that this could essentially just be handled by myself in this situation, unless if my client, Mr. Herman, is here, then he can by all means step in.
But he has waived the appearance with you. He's given you permission to proceed.
Yeah, so I did. He did. He said he wasn't 100% sure if he was going to step in, but I guess this is.
Right
I believe
you?
so. Yeah.
How's it going, Your Honor?
Hello. What's your name, sir?
Gerald Herman.
Okay. Bailiff, are you here? Yes. Will you swear him in, please?
All right, sir. Raise your right hand. Do you swear to tell the truth, the whole truth, nothing but the truth? So help you God.
Yes, sir.
Thank you. All right. Mr. Zimmerman, if you want to approach on the matter.
Yes, Your Honor. So as you had recalled, one of my former clients, he also had a bench warrant for a.
That's what I was asking a minute ago. Like, do we join this top so fucking well?
2024. As I also had stated as well, that there seems to, from what he had told me, that the ticket machines were not working at that time. Furthermore, my client had actually had his guard license revoked without realizing that there was a ticket infraction, and I'd like to get that cleared up on his behalf, Your Honor.
All right. So I did issue the initial order revoking the guard card, or the security license, excuse me, and the exposed firearm license attached therein.
Yes, I did see that, Your Honor. I'm asking if you can reverse that decision and reinstate his security licensing along with his gun registration licensing and everything else.
Okay, so he does have an active failure to appear warrant. So because he's here now, I'm going to ask the deputy to my right to process him quickly, get his fingerprints taken, make sure they match what's on file, so that we can formally clear the warrant, and then he can address the traffic infraction, and we can look at getting him his guard card back.
Okay, I have no objections to that, Your Honor.
Frank, you can tell the judge we don't object to that. I don't know if he's going to ask for our opinion, but...
All right, so that should only take a moment. They'll just go run him through AFIS down there, and they'll bring him back up. In the meantime, since he's given you permission to proceed, we'll just discuss quickly here the original circumstances. So I show this warrant issued November.
Yes, Your Honor.
The original infraction is just unsafe speed for prevailing conditions. Is there a reason that he has told you why he did not just pay that ticket?
I'm not 100% sure, Your Honor. He wasn't aware that he had a ticket as far as I was aware of. And then
well, he signed it.
I understand that, Your Honor. Whether or not he was just panicking or just forgot, I have no idea, Your Honor.
Okay.
I'm sure he can answer that for you. But yeah, I do feel that if he did try to pay the warrant back, or the ticket, pardon me, back in November, I do remember that there was some sort of technical issues with the receiving payments from the tickets back then.
Okay. For the state, I know you're not really read in on this one. I don't know if you've reviewed this at all, but essentially, I'll just summarize for the state.
Your
here.
Honor, can I just 1 second here for a second, Your Honor? He actually did mail a check. I just forgot, it was in my notes that I just forgot to read that. He did mail a check back at the time. And I believe that due to the postal services, I think they must have screwed it up by accident and forgot to give it to the courts.
Oh, those gosh mail people, whatever they're called now. All right.
I do
Just so the
apologize, Your
state's
Honor.
aware, just because we can't do this all one-sided, I got to get the state a chance to address this. The warrant did issue based on a failure to appear for an infraction. It's unsafe speed 52 and a 35. Does the state have any position on if he pays this now as to the reinstatement of his security license?
We have no objection to that, Your Honor.
Alrighty. So, Mr. Herman.
Yes, Your Honor.
I had a brief conversation here with your defense attorney, explained some of the hiccups that happened that led to this warrant. You got to make sure that you are checking your mail. If it comes back undeliverable or whatever happened there, I'm not going to get into the nitty gritty of it, but it is ultimately incumbent upon you to make sure that we acknowledge receipt of the payment. Otherwise, your promise to appear still is in effect. So that's why you were issued the misdemeanor warrant. Because you came to court and you did this the right way, you didn't make us go find you. I am going to let you just pay the ticket. We'll clear the warrant and you can have your licenses back.
Yes, Your Honor. Question, Your Honor.
Go ahead.
Do I have to reapply for the guard card?
No, sir. I'll issue an order reinstating both the security license and the exposed firearm license.
Okay, understood, Your Honor. Thank you.
All right. So before you leave the court, please make sure to go on to that website we have set up. Go to the clerk and make sure that gets paid. And then once I get notified that you've paid that, I will reinstate your licenses. I appreciate you taking the time to come in, sir.
Yeah, thank you, Your Honor.
All right. If there's nothing further, this case is adjourned.
I have nothing, Your Honor.
Funny.
Mr. Who do we have next here? Mr. Zimmerman, do you have any more clients today?
I believe I have a few more, at least one or two more, Your Honor. I think both of them are plea deals.
Your Honor, if I can request for my two docketed accounts to go ahead and move forward on those. I have a meeting in Vice City that I have to get to very shortly, or I'm going to be late.
Sure. You want to go with 0113 or 0114?
Either one. Both of them are plea offers. They should be cut and dry.
Both in custodies?
No, both of them are out on their own free will at this time. They should be in the courtroom now.
Your Honor, if our records are correct, there should be case 0113 and 0114.
All right, I'll call case 0113, the people of the state of San Andreas versus Devon Boyd. I believe he is in custody. I'm not sure, though. Oh, no, that's Mr. Boyd right there. I recognize his picture. Mr. Boyd, step forward. You'll be sworn in.
All right, sir, raise your right hand. Do you swear to tell the whole truth, nothing but the truth, so help you God?
I do.
Thank you.
All right, Mr. Boyd. Judge Reinquist, you have the right to remain silent. You do not have to say anything. There are several prosecutors in this room, and they will take whatever you say and use it against you. You have the right to ask to stop at any point to confer with your attorney. Do you understand?
Oh, I definitely do.
All right, sir. So you can go ahead and have a seat with your lawyer there. Hi, Mr. Boyd. You are accused of... Wow, you have a lot of stuff here. All right, let me start in order. In count one, it's alleged that on or about the 3rd of November in Los Santos County, you did knowingly commit the offense of battery on a peace officer. That's a violation of Penal Code Section 243, subsection C, subsection 2, which is a felony as charged. Count two, on the 3rd of November, you are alleged to have knowingly engaged in disorderly conduct, charged as a misdemeanor in violation of Penal Code Section 647. As to count three, you are charged with resist, obstruct, or delay of their duties, charged as a misdemeanor. It is alleged that you did knowingly delay and resist a peace officer by failing to follow verbal commands given that should be reasonably known to be valid legal commands from peace officers based on their uniform and marked patrol vehicles. Count four, allege a violation of Health and Safety Code 11350, possess controlled substance without prescription. That is a felony. Count five, you're accused of violating Penal Code Section 242, battery, a misdemeanor, in that you did knowingly commit battery on another person as alleged. And finally, you're charged with a violation of Section 422, subsection A of the Penal Code, making criminal threats. That would be on or about the 3rd of November. You did knowingly utter criminal threats upon another person, to wit, a law enforcement officer, as alleged. Criminal complaint before me. Does that sound accurate to the people?
That's correct, Your Honor.
All right, and then I have a plea offer before me here. The plea offer, count one, you would plead guilty or no contest. You would serve 6 months of formal probation with a suspended 1-year jail sentence for any violation of probation. Count two, if you agree to the plea deal, would be dismissed by the state's motion. The disorderly conduct charge. Count three, resist, obstruct, delay, would also be dismissed. Count four would also be dismissed. Count five, battery, you would plead guilty or no contest, serve 6 months of formal probation on strict compliance with the same suspended 1-year jail sentence for violation of probation, and the same conditions of probation must be followed. The charges to criminal threats, the state is willing to dismiss as well. And it appears you and your lawyer and the state have agreed to recommend to me that you serve 6 months of formal probation and a suspended 1-year jail sentence if you should violate your probation. There are additional conditions attached here. You are to complete a substance abuse evaluation along with any and all recommended treatment and submit a certificate of completion to the district attorney, who will forward it to this court. You will not enter bars, taverns, liquor stores, dispensaries, or other establishments where the primary source of income is derived from the sale of intoxicants, including cannabis. You consent to bodily substance testing at the request of law enforcement or this court, should reasonable grounds exist to believe you might be in violation of probation. You will complete an anger management treatment program and submit a certificate of completion to the district attorney. Should you fail to appear or violate the release agreement, be charged with a new crime, or fail to provide a full and accurate criminal history, this offer would be voided. It's also conditional on your stipulating to pay restitution as required and acknowledge criminal responsibility for the purposes of restitution. You further stipulate you would be required to appear at any such restitution hearing. Any bond that you have paid up to this point can be applied to the judgment should a restitution order be issued. To accept, you must plead no contest or guilty. I'll let your attorney speak as to how they wish to proceed before I have you say anything, sir. Mr. Stewart?
Your Honor, my client is willing to plead no contest to the charges being brought forth in compliance with the plea offer that the state has brought.
All right.
You're going to search. Go ahead. Sorry, I had a connection issue with my head.
And does the state agree with, as I have read the plea agreement?
Yes, Your Honor.
All right. Mr. Boyd, you understand that you're giving up certain constitutional rights by pleading no contest here, including the right to appeal this to a court of higher jurisdiction, to use the power of this court to compel witnesses to testify on your behalf, to use the power of this court, records, evidence, anything like that in your favor. Do you understand you're waiving those rights permanently?
Yes, I do, Your Honor.
And you still wish to plead no contest?
Yes, sir.
All right. The court will accept the plea deal and the plea of nolo contendere. You will be sentenced to 6 months probation with that suspended sentence of 1 year in the county jail if you violate any of the conditions of probation, which I read you your special conditions. In addition, the general conditions include you must obey all laws, municipal, county, state, federal, may not possess firearms, weapons, or dangerous animals. You must not leave this state without written permission from me. You must update the court of any address change within 1 business day. If you're physically able, you are to find and maintain gainful full-time employment, approved schooling, or a full-time combination of both. You will consent to a search of your person, property, or residence without a warrant should law enforcement request it. You will not return to the scene of the initial violation as alleged. You will not have contact with any named victim in the case. Bearing in mind that one of the victims named in this case is a law enforcement officer, so I'll leave that to reasonable discretion there. Just don't go out of your way to have contact with him. You will not possess or consume any narcotics or prescription medication without a prescription from a licensed medical doctor. You understand all of that?
Yes, I do, Your Honor.
All right. I'm also going to order that you be fitted with a scram device. That is a device that measures from your sweat the amount of alcohol in your blood at any time. Just given what the gravity of the offenses here that you have just pled to, attacking a police officer, making criminal threats, I want to make sure you're not drinking at any time, not just when I call you in for testing. All right?
Yeah, I
Your
got
Honor,
it, man.
It's my understanding that my client was never charged with anything involving the use of alcohol.
Oh, I understand. I don't think that he needs to be drinking any alcohol while he's going through his anger management courses and everything else.
Your Honor, if the state may.
Mr. Pearson?
This incident stems from the defendant being grossly intoxicated at the Blackwood Saloon and assaulting a deputy Stolas. So that is where the grounds of our alcohol condition requests come from, because this did have to do with the defendant being so heavily intoxicated that he believed that was the appropriate action to take against a peace officer. So the state does request that you impose a special condition as you are authorized to do so.
Any response to that, sir?
If I may, can I speak with my client in private over regards to this being brought up?
Well, you are aware he has already pled no contest, so he is convicted now. So, I mean, you can speak to him if you'd like to, but...
I understand. I just want to go over a little bit more in depth with him about what this would mean.
Yeah, not a problem. Deputy to my right, will you assist them?
Right this way.
And gentlemen, please make sure you're whispering back there. We have some weird acoustics in this courtroom.
The possession of cocaine and being at the bar, I would do the same thing. But shouldn't that be made out
The
in
scram
your?
tether is specifically why you do that too, is because it's somebody that you think is smart enough to get away with not drinking right before he gets tested.
We use scrams at my courthouse for what we call the Be Sober program, which is exactly what you think. It's about becoming sober, but that's just an acronym for the program.
It was one of those backronyms they came up with afterwards.
Exactly, yeah. It's like the city name, and it's like no, it's beginning, recovery, and something. Let me fucking look it up. It's on the website.
I was gonna say, given the conditions we put on this offer here, this is completely reasonable.
Yeah, no, absolutely, especially submitting to random substance testing, etc. Okay, it's the name.
Man,
of
it doesn't
this-
matter because technically he already pled, so like I can impose whatever I want. Like,
yeah. So okay, Be Sober. It's the name of the city. So B, sobriety opportunity for beginning recovery. Honestly,
if you can give me a good reason why not, I'm happy to entertain it, but we'll see.
They might have come up with that fucking acronym before in the name because that's just goofy. That sounded stupid.
Yeah, that's a backronym.
Yeah.
We want an acronym, and we're going to break our backs to make one. Who are you talking about? A deputy stole us.
At the time, he was deputy.
Who could that be? Nick, he sounds like a handsome fella.
I think you're just trying to get special favor on the next time I'm stuck with you.
You still have to do a Civ night sometime and have Southall have his ultimate crash out moment and shoot somebody. You don't need him anymore.
To my knowledge, he's a drunk that lives on the beach in Polito. That's the lore I keep saying about him.
He got canned and he fucking went off the deep end.
Yeah.
You need to have him get arrested someday. It would be hilarious.
Who's to say he wasn't drunk on the job sometimes? Y'all saw that Deputy Southall guy. Who's to say he wasn't drunk on the job?
Damn.
My apologies, Your Honor, for taking that time. After speaking with my client over the what you are proposing, he is at the understanding of it. Secondary to that, I would ask that my client be recommended or propose AA meetings in order to help with his alcohol dependency.
Sure. I am absolutely willing to add that as a condition. We'll get you through a 12-step sobriety program. It could be Alcoholics Anonymous or something similar, as long as it's approved by pretrial services.
Secondary, my client is already on a ankle monitor from his last hearing that he had regarding this. With the proposal of the monitor that you are speaking of, are you going to keep the ankle monitor on as a secondary device, or are you going to waive that?
So, Mr. Pearson can correct me if I'm wrong because he talks to pretrial services more than me, but I believe what we can do is replace the one he currently has with a multifunction. So it's a GPS tether and a scram all in one.
Yes, Judge, that is correct.
Perfect.
So-
My only worry is, it's embarrassing enough starting a new job and having one monitor on your ankle.
Yeah, no, I would
versus
not
him
ask
starting
him
a
to
new
wear
job
two.
and having dual
I
monitors.
understand.
Thank you, Your Honor.
So we'll remove the previous one and we'll have him get a new one installed by pretrial services that'll have the scram capability on it too. What that means, Mr. Boyd, is that if there's any alcohol in your sweat, it'll be reported immediately to pretrial services and you're going to end up here, but in an orange jumpsuit. Okay?
Yeah, I got it, man.
All right. Is there anything further from the people?
No, Your Honor.
All right. I accept the plea deal then.
VALE3. Okay.
VALET3.
Mhm.
I can just literally go into the hallway to my right
Alright,
and
so,
just swap into my guy. He's
the plea
already got a
deal
prison
is
outfit and
accepted. The
shit.
plea of no contest is accepted. The defendant will serve 6 months of formal probation on strict compliance following the conditions I mentioned, and the special conditions included in the plea offer. Counts 2, 3, and 4 are dismissed. And with that, this case is adjourned.
Thank you, Your Honor.
I believe next we have case 0114, which is an in custody.
That's correct, Your Honor.
You can have your client reach out to Corporal Stolas over at the Sheriff's Office, Probation Parole Department, if he has any questions about his probation or how to make sure his paperwork's set up right.
Perfect. I'll let him know.
Okay, perfect.
Fuck me, it's like a year and a half from I used this prison outfit. I'm sure the body types have changed since then. Oh shit. That's not gonna work. Come down and open the back. No, wait, I can open it anyways. I have that power. I'm gonna stand outside to do it. It won't let me do it when I'm in the interior.
I could try.
Damn it. Move on up here. Alright.
No, I'll look. I'll see how hard it would be to do. It's something with ticket tool, so I'll take a look at it. Not a big deal. I'll take a look.
Oh, I'm so sorry.
Yep. No, it's fine. I think I'm good now. Alright. Alright, come on back in.
Yeah.
Get me in the cuffs and I'm
Brody
ready to go.
Put Brody on it. He'd probably love that.
Sorry?
You okay, man?
Yes.
Okay, just checking in.
Is that her that smells?
I think so.
Christ, that is nasty.
Your Honor, if I may, can my client be removed
Just
out of
give
the
me
cuffs
a-
for his comfort?
Object to that.
He needs to be sworn too, so. The allegations here are quite serious, so I will, in the interest of fairness, allow his cuffs to be removed, but I'm going to have 2 deputies standing behind him in case he gets any ideas.
I understand, Your Honor.
Sir, can you please raise your right hand?
Do not start with the attitude. Do not be smirking at us here. This is serious.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Sure.
Yes or no, sir?
Yeah.
Take a seat, son.
If he gets up from that chair, deputies, you have my permission to restrain him.
All right, Your Honor.
All right, sir, state your name for the record.
Elias Brooks.
I need you to shout, sir. I can't quite hear you.
Elias Brooks.
All right, Mr. Brooks. You are charged with 8 counts. Count 1, in violation of Penal Code Section 417A1, brandishing a deadly weapon other than a firearm, charged as a misdemeanor. Count 2 is the same offense, charged as a misdemeanor. Count 3, the same offense, charged as a misdemeanor. Count 4, violation of Penal Code 246.3, negligent discharge of a firearm, charged as a misdemeanor. Count 5, Penal Code Section 417, subsection C, brandishing a firearm in the presence of a peace officer, charged as a felony. Count 6 is Penal Code 664 on the attempt of violation, Penal Code 187, attempt murder, enhancement, peace officer, charged as a felony. Count 7, attempt murder, peace officer, enhanced as a felony. Count 8, attempt murder, peace officer, enhanced as a felony. It is alleged that on or about the 19th of November in Los Santos County, you did knowingly brandish a deadly weapon, a knife, 3 times. It's also alleged on that same date you did negligently discharge a firearm, on the same date that you did knowingly brandish a firearm in the presence of a peace officer, and that you did on the 19th of November attempt knowingly to murder a peace officer 3 times. Do you understand the charges against you, sir?
I understand.
The combination of the charges present here has a maximum penalty of life without the possibility of parole in the state penitentiary. You understand?
Watch the profanity, son.
All right. I do find there is probable cause to proceed on the charges alleged in the complaint here. I will let the people speak to this first. I know there's a plea deal.
Your Honor, that is correct. We have presented a plea deal to the defendant here, and we'd like to proceed with that. Should they agree?
Mr. Stewart?
Your Honor, after speaking with my client during his time of incarceration and also speaking with the ADA and the DA, it is our...
Sir, sit up straight in your chair.
All right, bro, you got me.
Do not call him bro, son.
Sorry, Your Honor.
Thank you.
We are moving forward and accepting the plea offer that was brought forth.
Will he be pleading guilty or no contest?
We are going to be entering a plea of no contest, Your Honor.
And I understand there's to be an allocution as part of the plea deal.
That's correct,
Yes.
Your Honor.
All right, so the plea offer, the state moves to dismiss counts 1, 2, 3, 4, and 5, and have you serve a concurrent sentence, 6, 7, 8, attempt murder peace officer, 15 years in the state penitentiary upon a plea of guilty or no contest. You are aware that by proceeding here, you forfeit certain rights like the ability to appeal this to a higher court, to compel the presence of witnesses, or use the power of this court to compel the production of certain documents, records, evidence otherwise may be beneficial to your case. You understand all that, sir?
I understand, Your Honor.
All right. As to counts 1, 2, and 3, sir, I am going to accept the plea offer here. I'll enter no contest as to all charges. I will skip 1, 2, 3, 4, and 5, but I do need an allocution from you as to count 6, 7, and 8. What I mean by that is the state has alleged, and you have accepted without pleading guilty, but by pleading no contest, to the charges of attempt murder peace officer ×3. You need to speak to this court as to why those charges are alleged correctly, even if you do not admit guilt.
Okay. Sounds good, Your Honor. You want me up at the
So
podium?
I need you to tell me what happened on that day.
Do I go up to the podium or stay right here?
Stand up.
Yep, approach the podium.
Alright. Alright.
Deputies, please stay right with him. Mr. Stewart, just give the deputies a little room there.
So what do you need me to say, Your Honor?
I need you to tell me what happened on the day that you were charged with these crimes.
What happened is what you guys say happened. I stabbed those deputies. I shot that other deputy. I did that. No problem.
You attempted to murder those police officers?
Yeah, they got in my way.
Do you have any remorse for what you've done?
Sure.
You better wipe that look off your face.
Well, this is just the way my face forms, Your Honor. I can't do nothing about
That's a
that.
load of crap. You need to be respectful in this courtroom, especially
Don't play no
considering you
games
just
here,
admitted
son.
to me that you tried to kill 3 police officers. You are extremely lucky that you are being offered this deal, and I still can choose to reject it and force this case to trial.
All right, Your Honor. All right. You got me. You got me.
All right. You want to try that again, but with some sincerity?
Sure. I feel terrible about the acts I have done in the past to law enforcement officers and everybody else.
All right, sir. I will consider that to be a sufficient allocution. I sentence you to the custody of the Department of Corrections of the state of San Andreas for a term of 15 years. You'll be eligible for potential review release on good behavior after 8 years have elapsed. Do you have anything further you wish to say to this court?
Royals for life. Thank you, Your Honor.
All right, sir. You have committed some heinous acts, and I sincerely hope that should you see the light of day again, you have deeply reconsidered. You nearly took 3 people away from their families when they were attempting to protect and serve the citizens of this county, and I find that to be a crime beyond justification for anything. I don't care that you were in a gang. Those officers have spouses and children, and you were willing to kill them just to get away from, I don't even know what you were trying to do in the beginning, but I find it utterly reprehensible. And I find absolutely zero sympathy with you, sir.
Thank you, Your Honor.
Fucking wannabe gangbanger again. Get the fuck out of here.
You may take him away.
Your Honor, I ask that deputies do not misspeak to my client. If so, I'll move to file a lawsuit for defamation.
I believe that was the gentleman sitting in the gallery behind you there with the tie on.
Oh, sir, Your Honor. The deputy made clear remarks saying that he was a wannabe gangbanger as he was putting the cuffs on him.
That gentleman raising his hand back there, who are you, sir?
William Ponder.
Did you make that comment?
I did.
You did?
Correct.
Okay. Bailiff, will you go ahead and place him in contempt for now? We're gonna hold him. Mr. Stewart, do you believe that it was further these deputies that made such an allegation, or just that gentleman?
No, Your Honor. I believe it was him. From the way my ear was positioned, it sounded like it was the deputy. I do apologize for that outburst, but that is still...
No, I will not
insane.
tolerate that behavior in this courtroom, so... Bailiff, you could just bring him back here, have him... you don't have to take him all the way downstairs. We'll just have him get fingerprinted real quick, and then we can talk to him once we hear the next case.
Continue forward, sir.
Apologize for my slow spasm.
Your Honor, do you need anything further from me on either count? I do have a meeting to get to in Vice City.
Mr. Ponder, you better think about what you just said before you come back out here. Mr. Stewart, thank you for your time, sir.
You too. Thank you, Your Honor. Prosecutor. Prosecutor.
Mr. Stewart.
Okay.
All right.
You still got 128 left, right?
Let me double check.
I believe we've got case 0128 and 0133 remaining on the docket, Your Honor.
Your Honor, I represent Mr. Ponder here. I believe that's case 133.
What was the other one?
The other case is 128 with my client Ken Wild.
Let's hear 128. I want Mr. Ponder to have a minute to think about making those kind of comments in such a serious situation.
I don't disagree, Your Honor. I will say, though, on behalf of my client, of Mr. Ponder, I will strongly suggest to him that he apologizes to the courts and therefore makes aware that those are very serious things, and we'll go from there when it comes to it.
Sounds good to me, sir. Did you say your other client is here, or you don't know?
I'm not 100% sure, Your Honor. I believe he's here, but I'm not 100% sure.
Excuse me, Your Honor. I would hate to bother you, but I have a question.
Sorry, who's that?
It's me with the white shirt in the back.
It's a firefighter paramedic. Yeah, sure. Step forward, sir.
Okay. I don't remember what day it was, but I remembered I got stopped.
Well, what is your name, sir?
Oh, I'm sorry. My name is Jordan Rodriguez.
Okay. Go on.
I don't remember what day it was, but I remember I received a ticket from, I believe it was from Deputy Gardner. It was a traffic infraction for failure to yield. I think he said the court date was supposed to be for today. I just want to make sure because I don't want to be in trouble for not paying for that ticket.
That is correct, Your Honor. I'm seeing a citation for the defendant issued by Captain Gardner. Citation.
Was the defendant driving an ambulance when this happened?
Yes, Your Honor, he was.
Oh, boy. You're killing me here.
That appears to be citation 51880.
51180? All right, give me a second.
51880.
Okay, Mr. Rodriguez, what would you like to do? You here to plead guilty? Not guilty? Diversion? What are you looking to do?
I'm looking to play guilty because I must admit I didn't feel it. I wasn't yelling to him when he was on a traffic stop, and I almost, but not quite, killed him. So I'm here to play that ticket and go on with any consequence that you may have for me, sir.
Well, I certainly appreciate your being willing to admit the gravity of the situation you almost caused there. I'll accept your plea of guilty. You still are, I'm assuming by the uniform, you're still employed with American Ambulance?
Yeah, I've gotten talking to by my supervisor.
Go ahead and step up to that podium.
We've learned not to drive like that anymore.
Yes, he warned, supervisor warned me. He said if I drive like that again, and if I get caught like doing that again, then I'll be terminated from American Ambulance. Yes, sir.
Okay, because this is a case involving you operating an emergency vehicle as well, I am going to require that you pass a defensive emergency vehicle operations training again. You can get with pretrial services or the district attorney to arrange that. But you otherwise just need to pay the fine and points will be applied to your license. Be aware that because you possess a commercial driver's license, the threshold for suspension. So anything else like this happens again and you're not going to have a commercial driver's license, which I'm pretty sure is going to make it impossible for you to keep that job even if they don't fire you. So let's not have you back here again, okay?
Yes, sir.
All right. You can pay the fine either through the website or through the clerk in the hallway out there. I appreciate you taking the time to come in and take responsibility for what happened.
Anytime, sir. So I just walk out those doors and then go to the clerk out front.
Yes, sir.
Okay, thank you.
Have a good one.
Yes, well, thank you.
Your Honor, my client, Mr. Wild, is actually in holding in the courtroom here.
Okay. Bailiff, will you go grab him?
Yes, Your Honor. What's the name of the individual I'll be retrieving?
Mr. Ken Wild.
Mr. Wild, yes, sir. One moment, please.
He's pleading today, right?
Yeah, he's. We're entering a plea of guilty, Your Honor. I did have a serious talk with my client about this, and he does regret doing what he did.
Okay, I'd like to hear that from him, but I appreciate you letting me know. What's the case number on this one?
128, Your Honor. Oh, pardon me, Your Honor. I believe he's going to plead no contest. I was thinking about my other client, Mr. Ponder there, where he said he was going to plead guilty for that situation.
Understood.
To the right, sir. You can meet up with your attorney.
Bailiff, if you'll swear him in, you can remove his handcuffs.
Sir, you may go behind the desk. All right, raise your right hand.
Oh no, no problem.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Created by the shadow government.
Well, thank you very much, Mary Beth, for coming through.
Just
The
say yes, sir.
$5 tip.
Yes, sir.
Let's go.
All right, sir, state your name for the record. Make sure you're shouting, please.
Ken Wild.
Okay, Mr. Wild, you may be seated. As you have been told already, I'm going to remind you again, you have the right to remain silent. You don't have to say anything. If you do say something, there are several prosecutors in this courtroom who may use that against you. You have the right to ask to speak with your attorney at any point and confer with him privately should the situation dictate. We'll just read the charging instrument here quickly for you. You're charged with 5 counts today. Violation of Vehicle Code 2800.2, reckless evading, charged as a felony. Vehicle Code 23103, subsection A, reckless driving on a highway, a misdemeanor. Another count of reckless evading, charged as a felony. Count 4, reckless driving on highway, VC 23103A, charged as a misdemeanor. And count 5, resist, obstruct, or delay peace officer in violation of Penal Code 148, charged as a misdemeanor. It's alleged to have occurred on or about January 10th, 2025. I understand we have a plea deal before us.
Yes, Your Honor, that is correct. The state is recommending, the state's, good Lord, the words are escaping me. Long day. The state is recommending a sentence of 30 days in custody up front. At the conclusion of the 30-day sentence, 4 months of formal probation, all general conditions of probation to apply, with additional special conditions to not drive without a valid license and insurance. A 60-day license suspension, 48 hours of community service for a non-profit organization and a $1,000 fine. And the state is prepared to speak to the charges if the judge would like a factual summary.
Yeah, if you could provide a quick one for me here, just briefly.
Absolutely. Let me just
These
reference...
are quite a few reckless charges here.
Yeah, let me reference the original complaint for dates. So this stems from two different incidences. A deputy Stolas on January 10th attempted to stop Mr. Wild for a speeding infraction near 4000 on Sonora Freeway. Mr. Wild failed to yield and a pursuit was initiated. Deputy Stolas reached speeds of 146 miles per hour attempting to catch the defendant. Ultimately, the pursuit was terminated due to the danger to the public that it posed. That's going to give us the reckless evading and the reckless driving counts 1 and 2. About a week later, on January 16th, Deputy Stolas came in contact with the same individual driving the same car. The individual was asked to step out of his vehicle. He became less than compliant once out of the vehicle. That's where we get the resist, delay, or obstruct charge. He refused to follow lawful commands. He then jumped back in the vehicle. Another pursuit was initiated. And the defendant ultimately wrecked his car in a very serious, almost rollover accident near the Hookie's Diner up there off of Great Ocean Highway. Stemming again, that gives us again another set of reckless evading and reckless driving charges.
Mr. Wild, keeping in mind that you do not have to answer me, you realize that that was pretty frickin' dumb?
I do, Your Honor.
All right. Mr. Zimmerman, how are we proceeding here? Pleading not guilty, guilty, no contest? What are we doing?
Your Honor, we're gonna plead no contest at this time. That's all I can really say on behalf of my client.
Okay, how many days has he already been in custody for?
I'm not 100% sure, Your Honor. That would be up to Deputy Stolas and the state there to, I don't really have it on hand here.
He would have been in custody from the 16th, Your Honor. He was taken into custody on that date.
So I will accept the plea of no contest. Entered on the defendant's behalf. The upfront jail sentence I will reduce for time served to 15 days. I will impose the 4 months of formal probation with the general conditions of probation and special conditions as requested, that you will not drive without a valid license or insurance, that your driver's license will be suspended for 60 days. You will perform 48 hours of community service and you will pay a $1,500 fine. $1,000 as proposed in the plea agreement and $500 for court costs. Counts 1, 2, and 4 will be dismissed. Count 5 sentence will run concurrently with count 3.
Your Honor, one question about the driver's license suspension there. Is that after he is gone from, or after he's released from prison, or is it from the date that he was arrested?
It would be from today.
Okay.
Because I can't enter a backdated judgment like that, so it would have to be from today. If he wants to apply for a restricted driving permit, I am happy to talk about that, but I think that's probably better addressed on the next court date if you want to have him brought in for that, because I don't know why he needs a driver's license while he's serving his 15 days in jail.
Yeah, I'm sure that I can talk to him at a later date, Your Honor, in regards to if he has any temporary employment or if he's going to have to get away to do the community service.
All right. So.
Hey, what is up, the Tiger Gaming?
Mr. Wild, you are convicted as to the counts specified here. In addition, your general probation terms include you shall obey all state, federal. You will not possess firearms, weapons, or dangerous animals. You will not leave this state without written permission from me. You will update the court of any address change within 1 business day. If you're physically able, once you're released from custody, you are to find and maintain gainful full-time employment, schooling, or a full-time combination of both. You will consent to any search of your person, property, or residence without a warrant upon request from law enforcement. You will not return to the scene of the original incident. You will not have contact with any named victim in the case. Again, bearing in mind that the victim is a law enforcement officer, so I am asking you to not purposefully have contact with him. Additionally, you are not to possess or consume any narcotics or prescription medication unless you have a valid prescription issued by a licensed medical doctor. Do you understand all of that, sir?
Yes, Your Honor.
All right. Without objection, that'll do it for this case. The defendant's remanded to the Los Santos County
On your feet,
Sheriff
sir.
to serve a 15-day sentence.
I don't know if your guy's about to get held in contempt, Ponder. If the judge decides to hold him in contempt, why don't we handle the contempt case first? If he holds him in contempt, I'll amend my plea offer to whatever amount of days jail he gets. No probation, no fine, just a straight jail sentence, since he'll already be there.
Okay, yeah, I'm gonna make sure that
Is that not him right there?
I don't know. I didn't realize he got released.
I didn't either.
I'm going to make sure that I talk to him and let him know that he needs to apologize to the judge.
Why don't you let him know that now, and then I assume we'll call that probation case up.
Yeah.
Pardon me, contempt case, not probation.
All right,
Yeah,
and then we had one more in custody, or is that all of them?
That'll be that Ponder case, Judge.
Okay.
Your Honor, is it okay if I can have a talk with my client in regards to being held in contempt and making sure that he's going to apologize to you, Your Honor?
Absolutely. Yes, sir, you may. Where is he going?
It's the jury room, sir. Or can you get?
I have no idea, Your Honor. I think he just wanted to step outside.
Yeah, no. He's still under a contempt order. He's not leaving my courtroom yet. You can use the jury room to talk with him.
In the intervening time, Your Honor, did you want to see if there were any open court matters to address?
Sure. Any traffic cases here to be heard? Anything like that?
I've got some. Might as well.
Ma'am, you just stood up. You have a case for us today?
Yes, Your Highness. I'd like to talk about an arrest that had happened to me not too long ago.
Okay. Step forward.
Okay. Excuse me.
For the court's knowledge, this is Lori Matthews. I'm very familiar with her. She's supervised on probation. Last count I had, she has 14 arrests within the last year.
All right. Ma'am, you have the right to remain silent. Anything you say here will be used against you in court by the very prosecutor who is standing behind you. You have the right to an attorney. If you can't afford an attorney, one can be appointed for you at no cost. Do you have the financial means to hire an attorney?
No, sir, I do not.
Okay, we'll get you an attorney appointed. Do you know the record number for your arrests? Do you have a case ID, anything like that?
Yeah, yes, sir, I do. It was, they said it was record number 52515. I think that's what I wrote on my hand here.
Your Honor, I see an...
All right, yeah, I got it. I see you're charged with trespassing as a misdemeanor, disturbing the peace as a misdemeanor, and possession of drug paraphernalia not cannabis related.
Yes, sir.
Would you like to wait until you have an attorney, or would you like to proceed here?
I I would like to have an attorney, and I would like to I don't want to argue, but I think that's the correct phrasing
You
here.
want to fight the case?
Yes, sir.
All right. So what I'll do now then is I'll find probable cause does exist to proceed. I will order an attorney appointed for you. I'm going to enter a plea of not guilty on your behalf until such time as you are able to speak with an attorney. Mr. District Attorney, what are the bail conditions?
Your Honor, this defendant has an incredibly long litany of arrests in her life. I don't know how she continues to get out. I would motion the court she should be remanded until her pretrial conference. I don't think she'd come back to court. I can't believe she made it to court this time, to be 100% honest with you.
So, ma'am, what can you tell me about your ties to the community, things that might make me think you're not a flight risk?
Well, sir, I do not have a current abode, if you will, and I have had trouble getting back and forth to places where I have been requested to. I fixed my bicycle this past weekend, and I rode my way over here. One of the many issues I see, I have what they call IBS, so I can't stay, outside without access to a public restroom. And with the court being closed, it's been very difficult for me to get here. It's not a 24-hour service, if you will. So I've been staying at places that are commonly open, like 24/7s, and the Up and Adams, they're open 24/7. So I stay around there just in case I need access to a restroom. But I don't. I've with my past, I've only ran once, and I did not get very
ma'am,
far.
I do not want you to admit to anything right now. What I'm going to do is I'm going to appoint Mr. Baskin. He's sitting to your left. He can have a quick word with you about what you want to do from here.
Okay, where would I discuss this with him? I don't have a house.
Your Honor, we can use the room if that's okay with you.
Yes.
Thank you, sir.
And that final gentleman in the suit, did you have a case you wish to discuss?
Yeah. Yeah.
Okay, you may step forward.
I was here and
make sure you're shouting, sir.
I was here for the last court, and I was told I could pay a ticket or come up with some money for improper parking, and I was working not that long ago at I think it was a burger shop, and I was told that I had a warrant for my arrest or something.
What is your name, sir?
It's Will Travolsky.
Say it again?
Will Travolsky.
Travolsky.
I don't see any outstanding warrants in the system, Your Honor.
No, I see though he was arrested on the warrant and it was rescheduled for today.
I was just told to come here and to pay it off because I have the money.
So, I mean, the only charge against you other than failure to appear, which has already been dealt with, is improper parking. Do you wish to just pay that ticket now, or do you wish to contest it?
I wish to pay it.
All right.
How would I go about that?
All right, sir. So it looks like that is a $250 fine plus $50 court costs. You can pay that to the clerk out in the hallway, or you can go on our website and make that payment. Just make sure you do it before midnight tonight, or another warrant for your arrest will be issued. All right?
Okay.
All right, sir. I appreciate you coming in, getting this taken care of.
Thank you.
Now, Mr. Ponder, have you had a chance to, pardon the pun here, but have you had a chance to ponder in there?
Sir, and I would like to officially say I apologize.
All right, sir. I accept your apology. You can, bailiff, did you already swear him in?
Negative, Your Honor.
Yeah, go ahead then.
Oh, easy
Oh,
up.
not up here.
Easy up, Mr. Ponder. You can remain where you're at. All right, so you can raise your right hand. And do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You guys may be seated over here.
All right, Mr. Zimmerman.
Yes, Your Honor.
What's the case number for Mr. Ponder here?
It's 0133, Your Honor.
Okay, Mr. Ponder, you have the right to remain silent. You don't have to say anything. Anything you do say will be used against you by the prosecutor standing across from you. I understand you may be nervous. I just want you to understand that we are treating everyone fairly here by the standards accorded to you by the federal and state constitutions. You have a lawyer with you. You can stop at any point and ask to speak with him. But I am going to read out your charges here as a felony information. You're charged with a violation of Vehicle Code 10851, subsection B, subsection 2, taking a vehicle without consent, charged as a felony. It is alleged that on or about January 25th, 2024, in Los Santos County, San Andreas, you did knowingly enter into and operate a marked Los Santos County Sheriff's Patrol vehicle with clearly displayed emergency lighting and markings to indicate that the vehicle is owned by the County of Los Santos without permission and without good cause to do so, contrary to the laws, statutes, and ordinances in such case made and provided, and against the peace and dignity of the people of Los Santos County. Mr. Pearson, actually, if you'd like to speak on this first. I know there's a plea offer.
Absolutely, Your Honor. So the facts of the case, well, pardon me, I'll save that for after a plea's entered. Yes, the plea offer at this time is for 2 months of bench probation with standard conditions of probation, as well as 16 hours of community service. Because the defendant is pending a ruling from Your Honor for contempt of court, in the event that you do issue a jail sentence to the defendant, I would amend my plea offer and just request that he receive a concurrent sentence for this charge. As my understanding, they intended to plead.
So you dropped the probation and...
Yes, Your Honor. Just recommend a straight time jail sentence concurrent to whatever you have proposed.
Actually, Your Honor, looking at my files here, it's 2 months of the probation and $250 fine, no community service if we pleaded guilty.
That's correct. I had the wrong case pulled up. Apologies for that.
No worries. Your Honor, I would like to also ask as well that in the event that my client had knowingly moved the vehicle, but it was only to make room for the Los Santos Fire Department's medics to make sure that they can gain access to the patient. He does regret what he did, and he never wanted to take the vehicle, and it was not for malicious intent. He is also trying to gather a job, but unfortunately with having a felony record, it is harder for him to now get that, and I'm requesting that after his probation, if on good behavior and if he doesn't get any more charges, that the felony turns down into either a misdemeanor or just wiped off his record, Your Honor.
State would like to point out that the court does not have the authority to change the classification of the crime after a plea is entered. The state does acknowledge the limited criminal history, if any, the criminal history for the defendant. However, the state feels that the charging of this case as a felony is appropriate. The defendant had no right to enter the Los Santos County Sheriff's Office patrol vehicle.
Okay. Before I accept a plea, Mr. Ponder, I'd like to speak to you. Go ahead and step up to the podium. So, I get a lot of cases here. I will tell you that that is the first time I can remember reading a charging document saying that somebody moved a police car. You want to tell me what was going on there? I know your lawyer mentioned something about the fire department, but I'd like to hear it from you.
Okay, so it was a party. Can you hear me okay? Or do I need to speak louder?
Just make sure your voice box is on shout there.
Okay. It was a party at Mr. I forgot his name, but I've been in jail for a while. I was at a house party. I was recently picked up from Mr. Perez, which I don't think he's here today. He's not. I was picked up from him because I had a gun on me, and I was legally carrying a gun. He asked me, "Hey, make sure that everyone at this party is safe. You can drive people home since you just got out of the military and you had a license." So I go to the party. Everything's fine. Police were called already once for this loud music. I was checked out by the deputies. Nothing happened. Later, a gentleman fell into the pool. I go ahead and call 911. Let 911 know, the operator know that I am armed. A gentleman fell in the pool. Someone jumped in, saved him, and is giving CPR. I also advised the operator that I am a individual that's armed and open carrying. Law enforcement.
Was someone paying you to provide security at this party?
Yes, the house owner was, which I don't know if it's on file or not.
Okay, let me stop you right there. Before you say anything else, you're about to admit to another crime. So let's skip past that part because I don't want to drag you into another rabbit hole. So the guy fell in the pool, then what happened?
He fell into the pool. I called 911, all that. Law enforcement arrives. There was a marked patrol vehicle in the road. I, with no malice or intent, decided to get in the vehicle. This is from 8 years of prior experience from the Army, operating Humvees.
You served in the U.S. Army?
Yes. I really got out and got into civilian life 5 days, and then 5 days later I got arrested. Been in jail until yesterday. And sorry,
I'm not a
really
military man
changed.
myself.
Okay.
It sounds like something that you would describe as conduct unbecoming of a military man, to think that it would be okay to enter a police vehicle and move it instead of maybe going and asking one of the officers to move it.
No.
You have
Anyway,
any explanation as to that?
So the reason why I moved the vehicle, it's because the vehicle was in the road, blocking the driveway. I moved it forward, and then got out of the vehicle, did not touch anything in the vehicle, put it in park. I ran down, told the deputy, whosever vehicle I moved, hey, I moved your vehicle to make room for medics. Medical was able to park in the driveway and render aid. I will state that I did not touch anything. I'm sure your body cam or dash cam, whatever, can, and I was just trying to help with no malice or intent, and then I just tried to stay out of the way.
Okay, you're aware that our sheriff's deputies carry at least 2 long rifle and a shotgun in their patrol vehicles, plus God knows what else.
I am well aware. And as I
so
said,
the state could have charged you with tampering with those weapons, attempting to gain control of them. Honestly, just the fact that you're only charged with this alone, I think you might owe Mr. Pearson here a bit of a thank you.
And I do understand that the seriousness and what people may think of it. And I do apologize to the people and to the deputies of the county.
All right. With that all being said, I appreciate you taking responsibility here. I will just counsel you now that it is never acceptable for you to enter a police vehicle, especially it doesn't matter, you're trying to move it to help. Unless there is a life or death, like there is a person on fire in the police car, something like that, I don't want you to go anywhere near a police car. I'm going to make a condition of the sentence I imposed today. I'm going to suspend. I'm going to combine the contempt. I was going to give you a day in jail for contempt, but I'm going to suspend that. I'm going to find you guilty as to this offense. I'm going to impose a suspended sentence of 6 months in jail. That means that you do not serve any time in jail unless you commit additional crimes during that 6-month period. I'm not going to put you on probation. I'm not going to do any of that. I'm just going to have you check back in with me in 6 months. I'm going to issue you a summons to appear in 6 months. If you have committed no additional crimes at that point, then the suspended sentence will lapse, and you can apply for post-conviction relief through the procedures available to you. But unfortunately today, I have, as the district attorney correctly pointed out, no authority to independently reduce the level of charge brought against you. And I find that probable cause does exist, and the people have proved beyond a reasonable doubt that you are guilty of the offense of taking a vehicle without consent. The enhancement to felony is mandatory because it's an emergency vehicle that was stolen, or not stolen, but taken without consent, if my understanding is correct.
That is the state's position, Your Honor.
All right. So, Mr. Ponder, you have anything else you want to address the court about, Mr. Zimmerman?
Your Honor, I will request that after that 6 months, would it be okay if the courts can then remove that felony record on behalf of my client if he does
that's
not
what I mean
commit
by
any crimes?
post-conviction relief. So once he makes it through that 6-month period, and he can demonstrate one of the reasons applicable in state law for either sealing the record or expunging it, you can come back to me with that. Absolutely, we can explore that option as long as he doesn't commit any new crimes in the 6-month period of the suspended sentence.
Okay. I have no objections to that, Your Honor. Thank you.
All right. That sentence is imposed. He's already been processed for fingerprints. Mr. Ponder, I just want you to understand that when you're in a courtroom, doesn't matter if it's me or any other judge, you can't make comments like that, especially when we were dealing with somebody who tried to kill a bunch of cops. I will not have that for a second. That is the reason that you were arrested for contempt. I'm not going to direct the deputies to enter any kind of an arrest record about the contempt. And the district attorney was willing to lower his recommendation based on that. I did increase the sentence, but it's suspended. So as I said, you won't serve a day in jail if you don't do anything else wrong. So please take this as your golden ticket, because you're not going to get an opportunity like this again. If you get everything done correctly, you work with your lawyer, be a productive member of society, get a job if you don't already have one, do all that stuff. Don't do drugs, don't go off the deep end. Come back to me in 6 months and we'll talk about either expunging or sealing it. All right?
Yes, Your Honor. Thank you.
All right. I find you guilty. The sentence is imposed. This case is adjourned.
Thank you, Judge.
Sorry, you can leave, sir.
All right. Miss Matthews, is it?
Yes, Your Highness.
All right. Step forward. You can, I mean, you don't have to step up here. You can be with your lawyer back there.
Oh, okay.
Mr. Baskin, since you've had a moment to confer with your client there while we were dealing with some other matters, I'll let you address the court first.
Thank you, Your Honor. Just for the record, Michael Baskin, 241153, court appointed today. We've reviewed the case here, and we'd like to send you via email some reference showing a historic medical issue for Miss Matthews. Can we direct that to you by email as well as the state?
Yes, I believe you have the address for the court on file there. If not, I can provide it for you.
I got it right here. It's me 30 seconds.
Oh, fancy.
Red Devil Gamer, what is up?
There you go, Your Honor. We've just sent that over to you. This is a diagnosis report from a doctor at Pillbox Medical that Miss Matthews has submitted to me while we were discussing the case.
Oh, you're making me open Microsoft Word. Jeez. All right.
We apologize, Your Honor. That's the way it was submitted to us.
The state would put to you, Your Honor, I would never force you to do that. I would always convert my documents to PDF.
What is a PDF?
While I see you're being a kiss ass, Mr. Pearson, I appreciate it.
Thank you, Your Honor.
Defense would like that noted, Your Honor.
So noted. Okay.
Fuck you, Matt.
I see. I'm not going to read them out loud because I don't think there's any point in entering that into the public record, but that'll be in the sealed record here of the diagnosis. How do you wish to proceed in applying that to this case?
Your Honor, after consulting with my client and reviewing the information that we have in front of us, we'd like to note that Miss Matthews was not trespassing at the Up and Atom. She was simply using the facilities in accordance to the diagnosed medical condition. Therefore, we do believe that the trespass is unwarranted, and so is any other charges in regards here. It's a public bathroom, and Miss Matthews' medical condition does require easy access to that. Miss Matthews also did note to us that she tried to explain this to the officers and was asked to exit the bathroom multiple times. She was unable to do so until the business was taken care of, Your Honor.
Okay, so, well, I do have sympathy for her medical condition. A trespass does not need to be based on anything. It's just, it sounds to me like reading this arrest report that the Up and Atom employees wanted her gone. Now, I will note that the Americans with Disabilities Act could apply here, and so I will use caution proceeding on that ground. Would you be amenable to having your client attend a mental health evaluation? Just make sure that there's no further issues that haven't been uncovered here.
I would need to quickly consult with, or we can verbally ask Ms. Matthews in that fact, Your Honor. We do understand the ADA Act does require bathroom facilities for people in this specific case. Given the proximity of the Up and Atom to other public bathrooms, in this case, there was nothing else available.
Does the state have a position on that?
I haven't had time to review all discovery in this matter, Your Honor, as it was not previously docketed. I'm not prepared to speak to the probable cause at this time, or to what was or wasn't available for the defendant.
Your Highness, if I may,
ma'am, it's Your Honor.
I'm sorry. I'm sorry, Your Honor. I tried leaving, but they had broken a key off in the lock.
Ah, okay.
They told me not to mess with the door until they called the firefighters. So I physically could not leave.
Did the fire department respond and assist you?
They did. And in regards to, I think it was explained to me that I was disturbing the peace. All I was doing was yelling for help. I had a lot of pain, and I was just asking for them to call help because I couldn't get out of the bathroom, and I felt like I was dying.
All right. Mr. Baskin, does your client wish to invoke her right to speedy trial or waive that right?
It's my understanding she wishes. In that case, Your Honor, may I quickly whisper in her ear and confirm?
Yes.
And the state would just like to put on the record for all parties involved, speedy trial for an out-of-custody defendant is going to be 2 years. Speedy trial to a defendant in custody is 30 days.
Well, I'm about to see if she's going to remain out of custody here, so
yes,
I'm just trying to clarify.
Your Honor, my client would like to invoke her right for a speedy trial.
Okay. All right. So, with that being said, there are clearly some substantive factual issues here that need to be worked out. As far as I can see this trial and my concerns about the potential mental health issue here, I am going to order Miss Matthews' bond revoked. I believe she was released on her own recognizance. Is that correct?
Yes, sir.
That's what our records indicate.
Okay. So I'm going to revoke that bond. I'm going to place a $25,000 cash or surety bond, which means a licensed bail bondsman can post 10% surety bond on that. So I believe that would be $2,500. In the event that you're unable to come up with that bond, we will revisit your situation following your evaluation by mental health professionals. Now, part of the reason I'm doing this is because you explained to me you have nowhere that we can easily find you if we need you back in court. You don't have a fixed place of residence. You admitted that you need ready access to restrooms and it's hard for you to find food and stuff. I think that your interests are best served by spending some time in the county penitentiary as well. I think that that'll provide you 3 square meals a day, access to medical professionals, and a restroom will never be more than a couple feet away from you.
That's okay with me, Your Honor.
All right. Bailiff, you can take her into custody, and we will schedule this matter for the next docketed court date that council can agree upon. And I will order that she go through a mental health evaluation at Bolingbroke.
Are you going for jury or bench trial?
All right, Miss Matthews, is there anything on you
Say
that I
again.
need to be made aware of before we go downstairs?
Bench trial.
Okay, bench trial. Do you want to docket this for... It's a little outside the 30 days, but you can waive that on your client's behalf. The next available... Well, actually...
The 9th would be preferable. I do have... I do have a prior engagement on to the other day.
Okay. If we both agree 3-9, then let's docket it for a bench trial on that date, and we will be ready.
Works for me, sir.
All right, great. We have agreed upon trial date, Your Honor.
And what would that be?
It's going to be March 9th. Be Sunday, 5 p.m. And Mr. Baskin, if you'd like to
ordered.
If you'd like to let the judge know the style of trial you're requesting.
We're requesting a bench trial, Your Honor.
You spoke with Miss Matthews about that, waive her right to a jury trial?
Your Honor, I do apologize. It was my understanding with her that yes, that's what you prefer, but allow me to consult with her in a formal setting, especially given the current ordered evaluation, and then we'll send a note to the court.
All right. I will just direct the DA to make all accommodations for Mr. Baskin to be able to visit his client in the penitentiary.
Absolutely, Your Honor.
All right. And I believe that just leaves us with one case. Mr. Tucci in custody.
I don't. Are we, in your eyes, are we in the jail cell?
No, we're in the courtroom.
Okay.
Hello, Mr. Tucci.
Hello, I appear to have had a daydream or something go down. I don't have an attorney, as far as I know.
Okay.
I'll speak for myself, though, on this matter. I don't think attorney will be necessary for what's to be discussed today.
Where did...
there he is.
Okay.
Like I said, I had some sort of strange alien
That was strange.
daydream.
Like a parasite in your brain or something?
Yeah, do I need to blink, or am I
Just follow
my
me
good...
over here.
I think you might want to blink.
Okay, let me blink.
Oh, you know it. Oh, yes, sir. Yes. Can you send it to you? Sure.
Is it traffic citation he's fighting or arrest?
Yeah, he's under arrest for something else. He's just fighting traffic stuff right now.
Man, is this Joe guy switched to a different fucking character now to watch the case? He keeps going out and switching characters and coming back fucking in.
Is this my former comms guy?
Yes, I believe so. Joe D.
Joe D.
Okay.
He literally just swapped characters again. What is he doing?
Entertaining himself, I guess. Yeah.
That was not what I meant to do. Oh my god.
If I can get you out of those. There we go. Alright.
Alright, much better.
All right, sir. Could you raise your right hand for me? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help me God?
I do swear, yes.
And you are Mr. Bobo Tucci, that's correct, sir?
That's me, Bo Tucci.
All right. And Mr. Pearson, do you have the case number here?
If Your Honor could read it to me just to verify that I've got the right one pulled up.
Be 51278.
Thank you, Your Honor. Yes, I have that information pulled up.
So I see 3 charges here, sir, all of which are infractions, and as such, I know you are in custody currently, but you are not entitled to a court-appointed attorney because these are traffic infractions. You
Okay,
understand all that? You understand you have the right to remain silent? All the other things, you can hire an attorney at your own expense if you should so choose.
Yes, Your Honor, if I do recall...
Please make sure
I had
you're
a-
shouting, Mr. Tucci.
Yes, apologies, Your Honor. And if you do remember, I believe it was you, Judge, that spoke with me when I was present here last time. Handled some other citations, and there was an arrest actually that was part of this same debacle. You told me to appear here because Officer Gardner was scheduled this date. So I'm here to face my accuser.
So what he's done according to the records we have here, is submit a written declaration. Since this is only an infraction offense, you can cross-examine the declaration he's provided in the form of a video, and the state can do its best to try to assist here, but we're going to proceed off that basis, and then we'll make a ruling from there.
All right, let's proceed.
Thank you, Your Honor. State's ready to proceed.
All right. So, as to the 3 charges, I'm going to enter a plea of not guilty on your behalf, and we'll review the declaration provided by the citing deputy. Everyone will turn their attentions to the monitors in the court here. Dennis, you can go ahead and play it. Or do you need me to? So we're looking at the patrol vehicle of Captain Gardner here, correct?
That is correct, Your Honor.
Los Santos to Metro 559. Closing. 559. Los Santos to Metro 559. 559.
The defendant's vehicle will be the vehicle at the front of the line that appears to be bouncing up and down.
555. 559 Los Santos, I go check. You got me?
What?
I got you 555 now. Be advised, we have a theft coming in at 7338 East Mirror Drive. It's not in progress. $559 copy. You can show me in a road.
Get out of the truck! Get out! Turn around! Jerry, walk backwards. Turn around. Face away from me. Walk backwards, now.
Well, that was something.
The state would also put to the court that so, as we've all seen, the impeding traffic charge comes from the fact that that vehicle stopped and remained stopped at a stop sign longer than reasonably necessary. There was no cross traffic, but by choosing to utilize the hydraulics of the vehicle, therefore impeded traffic.
Objection, that vehicle was not equipped with hydraulics. I motion that
Sir, hold on. You're raising an objection on what grounds?
On the grounds of affirmative defense, that vehicle is not equipped with hydraulics. It is in the LSSO's impound, and I move to invoke affirmative defense of aliens taking effect of the vehicle due to unknown gravitational force, as you can see when Officer Gardner gets to the ending location of the traffic stop. The vehicle has an otherworldly motion, causing it to almost teleport backwards without the use of the engine. There was no backup lights visible on the vehicle. You
Your Honor,
may refer to the video.
Your Honor, the state's not talking about that allegation. That allegation is criminal in nature. I'm only addressing the actions of the vehicle at the intersection of Panorama and Joshua.
Okay. The objection in that case is overruled, I suppose, because it's not directly relevant here. As to the charge of impeding traffic, Mr. Tucci, I mean, how do you otherwise explain what you were doing at that intersection? Because from what I saw, it looked like you were causing vehicles to become backed up far enough that they were stuck on the railroad tracks.
I was confused by what the deputy in the blue vehicle was attempting to do, and I was having difficulty getting the vehicle to move due to the otherworldly physical nature of the vehicle moving. It was preventing me from pulling off of the roadway. It would be my response to district attorney.
And as to the other two charges, the registration and the insurance?
Your Honor, I've got documents here provided to me by the Los Santos County Sheriff's Office. They have placed a DMV and NCIC query of the vehicle with no return. I would submit that information for Your Honor's consideration. I have documents here.
I would respond to that by saying that
Your Honor, the state would object to the defendant's ability to make a statement at this time. This is my case. I am prosecuting it. He will have an opportunity during his case.
Mr. Tucci, Mr. Tucci, you'll get your chance to speak. Just bear with us for a minute here.
Well, Your Honor, you did ask for what my response was to those two charges, so I'm confused.
Sir, I'm going to ask you to remain silent until you're addressed.
Thank you, Your Honor. May I approach?
You may.
Thank you, Your Honor. What I have here is a return from the NCIC query and DMV query. We'll show you that a vehicle bearing the defendant's license plate, pardon me, it's on the paperwork. The license plate there was no return for it, indicating the vehicle is not registered. We also found no proof of insurance to be linked to said vehicle.
Did the defendant at any point during this whole encounter provide any sort of proof of insurance documentation?
Per Captain Gardner, no.
Okay. All right, I'll give you that back.
Thank you, Your Honor. At this time, the state rests.
All right. Mr. Tucci, now it is your turn to speak, sir.
Your Honor, I would like to say that I am not the registered owner of that van. I was informed by the organizer of that parade that the vehicle was lawfully registered as a quote-unquote work vehicle, and it was registered to the company Pride Brew, which were in charge of organizing the parade there, and that was my understanding. I was in the understanding that it was commercially insured as a work vehicle, and I had to provide a copy of my driving license, which is commercial in nature, when I took control of the vehicle.
But you never thought to look for a copy of the insurance? Because every vehicle, commercial or otherwise, you still have to carry proof of insurance, even if your vehicle is registered as a work vehicle, as you put it.
I don't have an answer to that.
Okay. And would you like to address the impeding charge further, or?
I think my only response to the nature of the impeding charge were that there was aliens at play, and Captain Gardner did not seem to understand that when he decided to place me at gunpoint. I was not attempting to back my vehicle up.
You saw the video as well, sir. How would he have known that?
Well, to be honest, I do not know. It is a very tricky situation, and you can imagine my surprise when I was placed into control of this vehicle and aliens started to have their way with it. As I'm sure you know,
Can
of
you
course.
cite any precedent as to alien tampering with vehicle?
Your Honor, I do believe that the state of San Andreas is not one who is foreign to such paranormal activity.
Well, for me to address it, though, I need you to cite case law for me because I can't just. I need controlling or binding case law that points to that being a mitigating circumstance.
I'm not prepared to supply that. I don't have a library card.
You are aware that they are free, right, sir?
I'm aware of that.
All right. Do you have anything further for the court?
I believe that's all.
All right. I will dismiss count 2 as to the registration violation. I will accept that it was a work vehicle and that the registration should have been provided in a different format, but I will dismiss that count, and I find of impeding traffic and failure to provide evidence of financial responsibility, the insurance charge. Those are both traffic infractions, so it's basically just going to come with points on your license and some fines. We'll address your criminal charges on a separate date.
Thank you, Judge.
Anything further from you, Mr. Tucci?
I would just like to address everyone in the courtroom. I've got the Desert Diva 3s coming out soon. It's going to be in all Binko stores.
Right. Enough. You don't get to just make general statements. If you wanted to talk to me about something, that would be one thing, but...
Your Honor, I would implore you to purchase...
No, I'm not buying any of whatever you're selling.
I'm ready to go back to prison.
All right. Bailiff, if you'd be so kind as to make that happen, the defendant is remanded to the custody of the sheriff.
In Your Honor, I do believe there's one final walk-in matter that may have checked in last moment. I got an email from the clerk of the court letting me know to hang out in case I'm needed.
Sure. Is that you, sir, with the white button-down shirt on?
Yes, give me 1 second and I'll get the information right.
I cannot hear you at all.
Make sure you're shouting, sir.
Give me 1 moment and I'll make sure to get that information ready for you.
Okay.
Most spasms. Name is James DeMarcus. I am here to essentially get my weapons back. I was placed under arrest for misdemeanor discharging of a weapon and for
Hang on, sir. You got to be sworn in before you start telling me stuff like that.
I got it.
All right, sir, face me, please, and raise your right hand. To your left. The other left. Thank you. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
All right, sir. You may proceed.
Hello, can everyone hear me?
I'm sorry, sir?
Hello. Can everyone hear me? Okay, my name is James Marcus. I was arrested on 2 misdemeanor charges. I believe this was 4 days ago. Let me get the case number for the DA. Give me 1 sec.
Your Honor, I've got a arrest report number for you if you'd like.
Please.
All right, I'm fairly familiar with this case.
50171.
That's not the arrest record, Your Honor. That's going to be the law enforcement's what they call ID number. The arrest record number is 52738. This will be for 1 count of negligent discharge of a firearm and 1 count of possessing an illegal large capacity magazine. Because of the nature of this case, Your Honor, these are both misdemeanors, and the defendant should be advised of his rights and offer a court-appointed attorney before he speaks.
All right, sir. So you have the right to remain silent. Anything you say here can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you at no cost by the state. Do you have the financial resources to hire an attorney, or do you wish to proceed pro se?
I would like an attorney, and I do have the financial resources to do so.
Okay. Is Mr. Pearson, is he out on his own recognizance right now?
To my knowledge, he is, Your Honor, and I will have probable cause statement for you when you're ready to allow you to determine if he should remain out of custody.
Okay. Sir, do you have other firearms other than the ones that were seized from you?
No, I have not bought any more yet.
All right, go ahead, Mr. Pearson.
Thank you, Your Honor. On or about January 28th, 2025, deputies were dispatched to a shot spotter. For the court's information, shot spotter system is an electronic monitoring system placed around the city of Los Santos. While I'm aware Your Honor may know what it is, just for the court's record.
Sure.
It detects sounds that appear to be gunfire, triangulates the location, and sends an automatic 911 call. Deputies were dispatched to a shot spotter alert. When they arrived, an individual that appeared to be Mr. DeMarcus entered into a 4-door wagon-style vehicle and appeared to have fled from the area. A short while later, he returned, and this is all in the area of 5031 on Barbarino Road. Once he returned, he was taken into custody, Mirandized, and it was later learned that he had discharged on the beach 120 rounds of 5.56 from a special carbine rifle within his residential neighborhood. He was subsequently charged with 1 count of negligent discharge of a firearm. I'm going to be amending that to 120 counts of negligent discharge of a firearm. He was also charged with possession of an unlawful large capacity magazine, 1 count. Per the arresting deputy, he actually had 4 on him. I will be amending that to 4 counts of unlawful possession of a large capacity magazine. That is a probable cause the state has put forth.
All right. Sir, do you have any response to that you wish to make, knowing that you still need an attorney to speak with? I mean, you could choose to remain mute at this point, and I can enter a plea of not guilty on your behalf.
I wish to remain mute at this point.
Okay. As to bail, is he out on a bond already, or is he OR'd, or what's going on here?
Based on the fact that it was only 1 count of each charge at the time, Your Honor, I believe he was released on own recognizance from the custody of the sheriff's office.
Okay. At this point, until you get a chance to talk to an attorney and we can further address the allegations here without me asking you things that might incriminate you and disrupt your right to effective counsel, I am going to remand you to the custody of the sheriff's office. I find that your possession of unusual destructive devices, being the large capacity magazines, represents a clear threat to the safety of the community. And I know you told me you don't have any further weapons, but the fact that the DA is going to increase those charges to the point that it sounds like 127 something charges in total, or I may have gotten the math wrong there. But I think you being out in the community at this moment is not beneficial to the safety of the general public. And I believe that you have a significant incentive not to return to court based on the charges before you.
Thank you, Your Honor.
Bailiff, you can take him into custody. And sir, I would just remind you, please do not speak to anyone at the jail until you get a chance to talk with a lawyer. There is a listing that will be provided for you at booking for lawyers you can contact. And they will get you, you can hire whoever you'd like there. And if it turns out that you cannot, in fact, afford an attorney, let the jail staff know that you need to speak with the judge again, and we can go through your financial means and see if you do qualify for a court-appointed attorney. Any questions for me? Okay, guess not. Goodbye. Mr. Zimmerman, Mr. Pearson, anybody else have anything?
No, Your Honor.
Nothing from the state, Your Honor.
All right. With that, this court stands adjourned.
Have a great rest of your
Appreciate
night,
you all
y'all.
taking the time.
Thanks for coming out to the stream. See you on the next one.
I'm off to go play some night golf.
Thanks, Judge. Have a good one.